All rise.
There's something very special about Ames, and the atmosphere in the courtroom is always electric.
Oh yay, oh yay, oh yay. The Honorable United States Supreme Court is now in session.
It's something that brings together the entire community. The Harvard Law School equivalent of a prize fight or the big game.
All those having business before the Supreme Court of the United States are admonished to draw near and give their attention.
It's the biggest audience for a courtroom argument ever. It's bigger than the Supreme Court courtroom.
God save the United States and this honorable court.
The judges take it incredibly seriously. You would never know this was just a fake argument.
We'll hear argument this evening in Reed Corporation and Norport Industries.
United States XRL Dale versus the Tech Corporation.
Duke versus United States. Counsel ready?
I mean, the right to privacy doesn't have the same kind of absolute protection as the right to religious belief. And I hope that you'll separate that. I'm talking here about belief only and not about religious conduct.
When you get to putting degrees on the First Amendment, you're going to get in more trouble than you will ever get out of.
Well, Your Honor, it seems that this court, with all due respect, has
is in that problem.
Is in that problem.
It's no surprise that the Ames Moot court competition has been a core tradition at the law school for 100 years, even through changes in technology.
It emulates the work of the finest appellate advocates. You have difficult problems, and you're expected to present them at a very high level.
I used to say about politics when I was still active that it's a strange blend of substance and performance art. The Ames Moot Court competition is also that blend, but substance is still king.
But I'm not sure what you say. It's not a legal term, but you used it in a brief, and you want us to use it in our opinion. You want us to say there's a presumption in favor of jurisdiction, for which I think is a rather novel, to use a polite word, a rather novel submission.
Presumption is defined a lot of different ways. Sometimes it talks about switching the burden of proof to the defendant. We did not intend to mean it in that way. We intended it in the way in which this court used it in Wheat versus the United States when they talked about the balancing and the weight that needed to be placed upon certain interests.
If I had to analogize it to music, I would say that oral advocacy at an event like the Ames Moot Court competition is like jazz. It looks effortlessly improvised when you perform, but hours and hours of preparation has gone into it.
We would watch videos of prior Ames oralists, and we would stop the video and discuss among ourselves what was going well, what was not going well.
We went out and practiced, swapping roles as judges, just throwing out questions as a group, keep honing them and trying to make the answers simpler and simpler until they sang.
The case that we argued, I think like most of the Ames problems, lent itself to tricky hypotheticals and testing the implications of the position. And so I remember our team just doing practice moot after practice moot and having to iron out how we were going to address the really tricky questions that we expected would come up at oral argument and did.
Well, tell me, Mr. Thomas, suppose Congress were to enact a statute saying that hereafter grants for the building of roads in any state shall be withheld unless the state enacts a mandatory law requiring the use of seat belts. Would you say that went too far?
Your Honor, the only fair answer to that question is it depends on how Congress...
I don't ask for a fair answer.
Well, I'm going to give you one, Your Honor.
It's a long night. So first you sit down to this dinner, and you sit through this sort of long discussion about what's going to happen. But if you're getting ready to stand up and argue, you don't care about any of that. You're like, stop this, end this, stop putting this, chicken in front of me. I want to go and do the thing I've been preparing to do for the, I know I don't want dessert and let's go, come on.
You use disability as a tiebreaker, isn't that right?
VITA does, Your Honor.
Yes. And why is that? If you are right, that seems just as inappropriate.
Under VITA's specific policy, Your Honor, which is separate from the overall run of cases, both employees were equally entitled to the position.
Well, then I would think that the employees would expect that you would flip a coin.
The key to a good oral argument is the ability to improvise, to adapt, to answer whatever question comes your way, in whatever order it comes your way.
The judges really put us to the test.
So I get up and I begin and I say, may it please the court, and I don't get a single another word out when the judge interrupts me and asks this very tricky procedural question.
One thing that has puzzled my colleagues and me is, as near as we can tell, you appealed from the grant of a summary judgment against your client on the promissory estoppel count, and there was no cross appeal that we see anywhere on the other counts. So why is the issue of the Americans for Disabilities Act even before us?
Your Honor, my understanding is that's an error in the record, that there was actually a cross appeal on that count.
All right.
Nothing quite prepares you for the full stream of questions from a bench that is very interested in learning more about your brief.
Balancing Papaya's burdens against the government's interest weighs in favor of the government.
How are we supposed to think about what an undue burden is? So the statute tells us that if it's a voluminous records that are being requested, that's too burdensome, right?
How much of the case takes up the relation of the military suppliers to the government? Certainly, your claims are basically against the suppliers themselves, aren't they not?
How could our system function if the Congress couldn't delegate substantial authority to independent commissions?
Isn't that a pretty good reason that we should abstain?
I want to know not what this court has said, but what you're going to say. I want an answer to my question.
Is there anything in the Constitution that compels this municipality to maintain a fire department?
So what should we do? Should we make an independent review of that evidence?
I do not believe so, Your Honor.
Well, then why are we talking about it?
Should the court try to fine-tune a protective order to give different degrees of protection to the different categories?
Do you really think, in view of the very specific legislative history of the Clinton Amendment, the court could responsibly do what you submit?
The court could certainly read the opinion.
Of course, with 5 votes, we can do anything, I suppose. Or in this case, 2.
Yes.
Isn't that part of the law of the receiving state, that there is that possibility of unconditional release? Or don't you know?
Well, I really don't know. Again, that is a question that's more in Mr. Nelson's bailiwick. And seeing that my time is up, I think perhaps I should.
There was a moment in the oral argument where I used the word comparator.
Your Honor, respondent has already alleged that a comparator exists in this case, and that's the only form of pretext she alleges.
Of what exists?
That a comparator, that a similarly situated person was treated differently.
Comparator. I never saw that word. Is that a word? C-O-M-P-A-R-A-T-O-R. Where did you get that?
And so in the moment, I had to try to excise that word from my vocabulary for the rest of the argument.
Your Honor, I think we found that in a half dozen cases or so, but...
Who wrote that?
He was treating us like real advocates, and in that sense, it was kind of a privilege that he wasn't changing the way that he questions lawyers just because we were students.
It was awe-inspiring to be in front of Justice Blackmun. But he did throw me one trick question. He asked me whether I remembered which judge had written the lower court opinion I was referring to. I happened to have gone to Langdell just that afternoon to review the cases. We still used books in those days, not online research. And I had made a mental note of who the judge was, and I answered his trick question to his surprise.
We went around and round, that's what delayed us. But we have finally concluded that the prevailing oralist is Miss Kathleen Sullivan.
What a judge really appreciates, I think, is the connection to the judge and the ability to really have a conversation with the judges.
It was very close, but to end the suspense, in the unanimous view of the judges, the best speaker was Mr. Singh for the petitioner.
For best oralist, Amanda Mundell.
hard to take yourself out of that moment and ask yourself, were you the best team? Did you argue the best? And knowing that after all the hard work we had done, that we came out victorious was both surprising and wonderful.
I certainly look back on the Ames competition of a long, long time ago and can remember everything that happened that night.
These moot courts are great so far as I'm concerned. It's important to these people, and I know how much time they put in it, and how much sweat, and how much argument, and how much everything just short of fisticuffs that go in writing a brief and preparing for the argument.
I decided very early in my first semester that I wanted to participate in an Ames final. And I decided the easier way would be to get appointed Chief Justice and come back as a judge than to do what you all have had to do.
There is no better preparation for the collegial work of law practice than having a team, working together to come up with the best briefs, honing the briefs, reworking them, carrying the issues back and forth with one another, and then preparing for oral argument.
There was a gravity and a respect for what the law was for and how precedent had evolved that I wish was more part of the experience in practice today.
People who participate in Ames already have the bar set so high for them in terms of what they expect of themselves as appellate advocates that they never are anything less after that.